Hello friends, in the series on the income tax cases, today we have come up with a case on prosecution proceedings which are being initiated against the assessee for late deposit of TDS. As we have already discussed in many videos on prosecution proceedings for late deposit of TDS, that the crux of the cases is that if the assessee is not a serial offender and if the penalty proceedings has not been initiated against the assessee and directly prosecution has been launched, and if the assessee makes default good by depositing the TDS on time, and if the assessee is able to make a reasonable cause that there was delay but that delay was not intentional, then whether in that case the prosecution proceedings should be continued against the assessee. This issue has been taken up by the Honorable Supreme Court in the case of Income Tax Officer versus Sengoda, Gounder Educational and Charitable Trust. This case is reported in 478 ITR at page number 356 and the date of the judgment is 8th July 2025. Before proceeding further, it is very necessary to understand three sections. First is section 200, which talks about duty of the person deducting tax. The second is section 276B, which gives the power to the revenue to initiate the prosecution proceedings for not depositing the TDS as per the provisions of the Act. It may cover non-payment of the tax or deferment of the payment of the TDS. And accordingly, there is section 278AA, which talks about reasonable cause. If the assessee is able to give the reasonable cause for the non-deposit of the TDS as per the provision, then the prosecution proceeding should not continue against the assessee. With this background, the facts of the case is like this. The assessee is a engineering school. In the case of the assessee, there was some delay in deposit of TDS each time by 7 months. When the notice for initiating the prosecution proceedings was sent to the assessee gave reply and said that in the case of the assessee, the staff which was handling this TDS matters, she was a lady and she has gone for the maternity leave, and that is why the delay has caused in depositing the TDS. The assessee has come up with the explanation that the delay was not caused wantonly. The assessee said that there was no deliberate or dishonest intent behind the lapse to remit the TDS. But the revenue authorities were not convinced and they went ahead with the prosecution. So when the matter was before the Honorable High Court, through filing the writ petitions, the court said that in the present case, there is no doubt that the delay was rectified by the assessee subsequently, and the assessee has demonstrated that there was reasonable cause as per section 278AA by saying that the staff which was handling the TDS matter was on maternity leave. The revenue has not counter that argument of the assessee. So from the whole facts of the case and from the whole conduct of the assessee, the prosecution proceedings are liable to be quashed. Friends, this case seems to be very easy, that you go to the court and you are able to demonstrate that there is reasonable cause, but it all involves a lot of pain, a lot of botheration for the assessee to go to the court in the prosecution proceedings. It is not simple fiscal proceedings. You have to stand in the queue with the criminals. So try to avoid any compliance delay. There should not be delay on the part of the assessee which are very casual in nature. Whenever you have to deposit the tax, try to deposit the tax in time. So it has been seen that some assessees just delay the deposit of the TDS for their laziness. It should not be the case. If you have the money in your accounts, the tax should be deposited. It should not be taken as casually, because the non-deposit of the TDS as per the provisions of the Act can land you in the prosecution proceedings, which can be very fatal in terms of monetary terms and in terms of mental botheration for the assessee. At the end of this video, once again I am repeating the name of the case. The name of the case is Income Tax Officer versus Sengoda, Gounder Educational and Charitable Trust, and this case is reported in 478 ITR at page number 356, and the date of the judgment is 8th July 2025.